Generally, the hearsay rule prohibits a witness from testifying as to unsworn out-of-court statements to prove the facts asserted in the statements are true, unless an exception applies. But can a witness's testimony about his or her own out-of-court observations be considered hearsay evidence? In City of Webster Groves v. Quick, the Missouri Court of Appeals said not so fast. In March of 1957, at about 8 in the morning, Preston Quick was driving westwardly on Kirkham Boulevard in Webster Groves, Missouri. While driving, Quick approached a parked police car on the same road that was facing in the eastward direction. At the same time, there were no other vehicles driving on the road. The officer saw Quick's car approaching and, believing it was traveling at a speed in excess of the speed limit, pulled out his electric timer. After clocking Quick doing 40 miles an hour in a 30-mile-per-hour zone, the officer stepped out of his vehicle and waved Quick down. The officer then showed Quick the speed readings and explained to him how the machine worked. Subsequently, Quick was given a ticket for violation of a speeding ordinance. Quick pleaded not guilty, and a hearing was scheduled in the City Court of Webster Groves. Following the hearing, Quick was found guilty, and he appealed the decision to the St. Louis County Circuit Court. At trial, the prosecution introduced testimony of the officer who pulled Quick over. Specifically, the officer testified that he had looked at the electric timer and that it had read that Quick was traveling at a speed of 40 miles per hour. Following trial, Quick was found guilty and given a $10 fine. Quick appealed to the Missouri Supreme Court, which transferred the case to the Missouri Court of Appeals.